I'm sorry.
Good afternoon, everyone. I'm Annalise Emmons. I'm the editor-in-chief of the National Security Law Journal. Thank you so much for joining us today. This afternoon will begin the first part of our two-part symposium series, Starting and Ending Wars, Charting a Course from Conflict to Resolution in the 21st Century. In this symposium series, we're going to be examining both the legal and policy challenges surrounding the initiation, conduct, and termination of armed conflict. This morning, we're delving into part one, which is the first move, presidential power, AUMFs, and legal architecture of starting modern wars. Before I hand off the stage to our moderator, Cornstone, I would like to first thank our guest speakers for being here today and joining us, and also to our counterparts at NSI for making this all possible. With that, I would like to pass off the stage to Corin to begin our symposium.
Great, thank you, Annalise. So I will start without a microphone, and if you can't hear me, give me a symbol and I will pick up the microphone, but I'm usually pretty loud. So first of all, thanks so much for having us here. Thanks to the National Security Institute, and thanks for the National Security Law Journal for hosting such an important conversation today, very timely, of course. Glad to be here, and we have an incredible panel that I will introduce in a minute, wealth of information. So really glad to be here. I just want to start by saying we're all speaking in our personal capacity, so please do not attribute anything we say here to any of our organizations. It's all purely personal capacity. I'm going to leave about 15 minutes at the end for questions. So we have a lot to talk about, and I will jump right in. I'll introduce myself first. I'm Corin Stone. I'm Chief Counsel and Senior Advisor to Senator Alyssa Slotkin. I cover, in addition to all things legal, our AI policy portfolio, and I'm part of the national security team for the legislative team. My background is mostly in the executive branch. I was the Deputy General Counsel at the Department of Defense a few years ago. Prior to that, I was in senior legal and policy roles across the intelligence community. I was the Deputy General Counsel at the ODNI for a while. I was the Executive Director of the National Security Agency. I was the Deputy Director of National Intelligence for Strategy and Engagement, and a handful of other things. So that is my background. I came to the Hill, to the Senate in January. To my left is Governor Jim Gilmore. So Governor Gilmore is an Army counterintelligence veteran, a public servant, and an attorney whose distinguished career spans law, governance, and national security. He was born and raised in Virginia, and he earned both his bachelor's and his law degree from the University of Virginia. As I said, he served in the Army, he practiced law, and he was the chief prosecutor for Henrico County before he was elected as Virginia's Attorney General in 1993. In 1997, he was elected as Virginia's 68th governor, during which time he established the first Secretary of Technology cabinet position in the nation and focused on creating jobs, among many other things. And he was also in this position during 9/11. Following his tenure as governor, he ran for the GOP nomination for president from July 2015 to February 2016. And he was in 2018, Governor Gilmore was nominated to serve as the U.S. representative to the U.S. mission to the Organization for Security and Cooperation in Europe, OSCE. This is a position that carries the rank of ambassador and is based in Vienna, Austria. His nomination was confirmed by the Senate in May of 2019, and he served in that position until January 2021. So thank you for being here, Governor Gilmore. To the governor's left is Professor Paul Ahern, who many of you may know. He is an adjunct professor here at the Antonin Scalia Law School, teaching national security law. He's also the U.S. Treasury Department's Counselor for Enforcement, where he's charged with coordinating the operational enforcement activities of Treasury's Office of Terrorism and Financial Intelligence. He previously served as the Principal Deputy Assistant Secretary and Acting Assistant Secretary in the Office of Terrorist Financing and Financial Crimes, which works across all elements of the national security community, the private sector, and foreign governments to identify and address the threats presented by illicit finance. Before this role, Paul was the Assistant General Counsel for Enforcement and Intelligence, where he oversaw the provision of legal advice throughout that organization. He began his Treasury career as the Senior Counsel to the Department's Intelligence Community element. And before joining Treasury, Paul was a trial attorney at the U.S. Department of Justice, assigned to both the counterterrorism section of the National Security Division and the Fed Programs branch of the Civil Division. He clerked on the 7th Circuit, and he also served as an officer in the Army. Thank you for being here, Professor Ahern. Next to Professor Ahern, we have Katie Shadoin. Katie is the senior counsel to the Senate Foreign Relations Committee and the chairman's staff. Prior to joining the committee, she served as lead advisor for national security issues to Senator Martha McSally, handling the Senate Armed Services Committee portfolio. Previously, she worked in the Georgia congressional delegation as a counsel to former Senator David Perdue. Okay, adding the mic, sorry. Can you hear me? Okay. Katie earned her bachelor's from the University of Georgia, the School of Public and International Affairs, and she got her law degree also from the University of Georgia School of Law. And she also studied international and comparative law and policy at the University of Oxford. Welcome, Katie. And at the very end of the table, we have Mark Iozzi. He is the Deputy Chief Counsel for the Senate Foreign Relations Committee Democratic staff. So he's the minority, she's the majority. He previously served at the State Department as a Deputy Assistant Secretary for Conflict and Stabilization Operations, where he led efforts to prevent and respond to conflicts in Asia, Africa, and the Western Hemisphere. Previously, he was a national security advisor and senior counsel to the Democratic leadership of the House of Representatives and the Deputy Chief Counsel to the House Foreign Affairs Committee. Mark was a Peace Corps volunteer in Kyrgyzstan and holds a law degree from Georgetown and a bachelor's degree from Western Washington University. Thank you for being here, Mark, and welcome to everyone. So I'm going to start with the big picture here. As many of you will recognize, it's been more than 2 decades since the 2001 Authorization for Use of Military Force was passed. And since then, it's been used to justify the use of force in more than 20 countries in many different contexts, probably contexts that were not contemplated by the drafters of that AUMF, but is still very much the legal foundation in US law for the president's use of force against terrorist organizations. So is the continued broad use of the 2001 AUMF a constitutionally sound approach to justify the president's actions to combat terrorism? Or is it a failure of Congress to exercise its fundamental power to declare war? And how does the president's Article 2 authorities play into this analysis? I think we're going to have a conversation about all of these topics, so everyone will jump in as they want to, but I'm going to start this conversation off with Governor Gilmore.
Okay, well, y'all can hear me just fine, I think. Okay, let me start off by assuring my fellow panelists and the moderator that I will be brief instead of trying to be monopolizing things. But I do want to add a few essential points, I think, maybe to kick us off. I am a former chief executive because I was the governor of Virginia. So I was running the government, including all of its security issues, and was governor during the 9/11 attack, which I can talk to you about that at a later time. I am a lifelong conservative Republican, and therefore one of my touchstones has been the liberty of people. That's really sort of what my foundation is. So I approach this issue today on that basis. I am a checks and balances guy. The more history I read, the more I realize that anybody who's in charge of an army and secondarily a police force, as we've seen in places like Russia and China, they can impose themselves on the people because of that force. The founders were clever enough to understand that checks and balances was the only thing that probably kept people free. So I'm that kind of guy. I would say a few things. First of all, the Cold War created some exigencies that maybe are pretty unfortunate. But during the time when the United States was fighting the Soviet Union, there was a fear that a missile could land on us with very little warning, and so the executive branch was going to have to be empowered to respond immediately. And we fell into that pattern over those years of the Cold War. The world today, I think, is a lot more dangerous than the Cold War. This is a real dangerous situation. And I believe, and I've been lecturing on it all over the place since I came back from my ambassadorship in Vienna to the OSCE. I don't have to work, so I'm actually trying to help the country by speaking on these international issues specifically the Ukraine war. Well, as a former chief executive, I wanted to secure as much power as I could to myself to do what I wanted to do. And I ended up in a battle with the legislature, so it was a miniaturization of much of the discussion that's going on today. But in preparation for this, I might say this. I promised myself I would present this so I could put my hand on it. This is Foreign Affairs magazine. I read it cover to cover every quarter. And this one is November, December 24. And the theme of this book is World of War. And that captures pretty much the way I think things are. I think that the world is in a conflict and it's only beginning. And that is because, in my view, there are at least two powers, the Russians and the Chinese, that want to remake the 21st century. They don't like the way that things have ended up with Western values and a country like America leading the way with our allies. They just don't like it, and they have a different vision for the 21st century. So the first policy question we all have to make, particularly you, is what kind of world do you want to live in the 21st century? Because we're getting ready to have that decision made over the next number of years. So I'm just going to cite a few points. Article 2 grants executive power to the president to be the commander-in-chief of military forces when called into action. I have reread it again yesterday, and I certainly can't find any authority in it for everything that's going on right now, frankly. But Article 2 is heavily leaned on as a constitutional basis for executive authority and all these things, military, of course, and beyond, in the war that we're in. You want to read the UN article, the UN Charter, and particularly Article 51, which says that a country has the right to defend itself by military action until the Security Council decides to act. And of course, they can't act because the Chinese and the Russians have veto power over it. The war power resolution of the Vietnam period in I believe it was 73 is a very important point, because at that point, people had believed that Lyndon Johnson and others were exercising too much executive power. The War Powers Resolution, the anti-Vietnam resolution, was intended to be a check and limit on the executive branch. It says they can't deploy troops except for 60 days and a 30-day wind-down period without the authority of Congress, and that there's a reporting notice that has to go to Congress. So this was an effort for Congress to try to reassert themselves a little bit at the end of the Vietnam War. And then the next thing that I want to talk about, or I want to just note, is the 9/11 attack. Now, again, I was the governor during the 9/11 attack. And in fact, I had been chairman of a congressional commission on Homeland Security for 3 years before the 9/11 attack. And it was extended 2 more years. So I actually chaired that commission, which came to be known, I'm proud to say, is the Gilmore Commission. If you want to look it up, you can look up Gilmore Commission, Rand Corporation, and find the 5 reports. And we warned that there was a likelihood there was going to be an attack on the homeland, probably not a nuclear attack, or God forbid a biological attack, but some kind of a major attack on the homeland, which was, of course, summarily ignored. And then the 9/11 attack occurred. I can tell you some interesting stories about that. But the main thing I will point out is that I believe that at that time there was a sense of complete, particularly political hysteria and panic. And as a result of that, the politicians all said, boy, we really screwed up here. We didn't anticipate this, so we've got to tell the American people we're going to do something. So the Congress passed this resolution, this joint resolution, 7 days after the attack, granting very broad policy authority to the president to defend the country. President Bush responded by going to the Congress and saying, well, you're either with the terrorists or you're with us, or you're against us, which was a very broad statement. And then a few days later, John Yoo, the legal advisor to the president, published a memorandum of opinion, which I would encourage all of you all to go find. It isn't that easy to find, but it's an interesting advice to President Bush, in which, in summary, he basically said there's a unified theory of political power here. The president has complete authority. He used the word plenary in his opinion over and over again. That caused me to go look up plenary in Webster's, find out what that really means. And what that really means is unchecked, complete power, total. No check of any kind, which of course raises the question, what was the point of the authority for the military force that was passed by the Congress several days before that? Because John, you was taking the position that President Bush needed no authority from anybody, anywhere, at any time. I would encourage you to read that startling memo. So that is the opening statements I think I would make about these issues that I think sets the stage for, I think, the discussion that we're having today. I remind you for the second time, we are at war. We're at war right now, and it's only the beginning of the war. And you all will be engaged in it probably for most of your lives. And it's going to be answered in large measure by many of the issues brought up by this symposium.
Yeah, thank you. Thank you for that context. And Paul, do you want to talk to us now? So that gives us sort of how did we get here? Maybe you can talk about whether we should be and have been using the AUMF properly over the course of the last 20 years.
Sure. Thank you. Thank you very much. Thanks for having us, obviously. It's nice to see so many friendly faces on the audience. You're friendly, especially if you haven't finished my course yet. After that, maybe less so. So I want to, Governor Gilmore obviously started with Article 2. I think that's an important place to start. He mentioned the different clauses within Article 2. I think that it's uncontroversial that the president maintains some sort of core authority under the Constitution when it comes to the national defense. And that comes from his oath to protect the Constitution. That comes from his status as the commander in chief. It comes from the vesting clause and the take care clause. So we have that to take a look at. The Supreme Court has given us a couple of benchmarks in this area, and I just want to briefly focus on two of them. The first was the prize cases in the Civil War, and basically that stood for the proposition that Congress didn't have to act in order for President Lincoln to impose an embargo on the southern states, which were in a state of rebellion. And the way the Supreme Court described it, the president found himself in a state of armed conflict. And he's not just authorized to deal with that, but he's bound to deal with that. So a very, very broad conception of sort of the world maybe that we find ourselves in. I want to just kind of quote what Justice Greer said about this circumstance. However long may have been its previous conception, it nevertheless sprung forth suddenly from the parent brain, a Minerva in the full panoply of war. And so that's sort of like the idea that the war has been thrust upon us and the president is bound to deal with it. The second sort of guardrail is in the Youngstown case, the steel seizures cases. So what we know from that case is that the president is not authorized in a circumstance of an undeclared war to seize U.S. industries in order to prosecute an armed conflict. So those are sort of the two guardrails I think we have. It seems to me that the world that Governor Gilmore is describing, the world that we found ourselves in after 9/11, is much more like the conception in the prize cases than anything else. This is a conflict that has been thrust upon us. And in fact, we were in this armed conflict, I think, well before we even realized it. If you look at the decade before 9/11, you had the first World Trade Center bombing in 1993. In 1998, you had two of our embassies in East Africa bombed, killing 224 people. In the year before 9/11, Al-Qaeda bombed the USS Cole, tried to take out a military target. And that's just in the previous decade. Now, if you go back to the 80s, we have a bombing of our embassy in Beirut, as well as the Marine Corps barracks, a bombing of a German discotheque where U.S. soldiers were present in order to get at those U.S. soldiers. The Pan Am bombing in 1988 over Lockerbie also. So if you think about it like that, we were in an armed conflict for maybe 2 decades before we even sort of realized it on 9/11. So with that as background, I want to turn to the AUMF. And some of my students will know the story of Holmes Baldridge. Okay, Holmes Baldridge was the Justice Department official who argued the Youngstown case in the district court. And they will also know the sort of risk of putting all of your argumentative eggs in the Article 2 basket. So even if there is sort of Article 2 authority here, I want to focus briefly on the AUMF and what it actually provides. And I think we're going to talk about some of the limitations, I guess you could read into it, and whether we read those into it. But the preamble to the AUMF, which I carry around with me in case I get bored on the metro. It refers, first of all, to the 9/11 attacks themselves. And then it becomes more broad. It refers to such acts render it necessary and appropriate that the United States exercise its right of self-defense. And then says that such acts continue to pose an unusual and extraordinary threat to the national security and foreign policy of the United States, and then recognizes explicitly the president has authority under the Constitution to take action to deter and prevent acts of international terrorism against the United States. So broadly speaking, acts of international terrorism is the purpose for which Congress is authorizing this. And one could look at the AUMF, and I'll leave it at this for now. We can sort of explicate this later, but you can look at it as a congressional response to the failure to deter terrorists in those 2 decades leading up to 9/11, and in particular, after the 1993 World Trade Center bombing, we treated it like a law enforcement problem. So no sort of military response. After the embassy bombings, we fire a couple of cruise missiles at a chemical plant in Sudan and a training camp in Afghanistan, and that's it. No further step taken. In response to the Cole bombing, just a year before 9/11, we did nothing. And so, I think it's worth, as we talk about the AUMF and its enduring value, thinking about the context in which it arose and what Congress was trying to authorize the president to do to make sure that something like this never happened again.
Can I add something before we go to the third panel, just very quickly? Is it off? Is it on? No. God, I hate these things. There we go. Just very quickly before we go to the third panel, let me point out in reaction to some of the things that Paul said. I think you ought to go read this authorization for military force carefully. There's no doubt in my mind that even though that the entire American government was in an abject panic after the 9/11 attack, that resolution was intended to be directed towards the people who had caused that attack or the people who are harboring them, Afghanistan. That is what that's really all about. Now, Paul points out the language is broad. It gets broader, particularly if a chief executive wants it to be broad and wants to interpret things in that way. But when I read it, it really looked to me like they were really focusing on Al Qaeda, who was of course, the perpetrator. But the second point quickly is this whole business transitioned from World War II and later focus on nation states we were at war with, including North Vietnam later on, into a war on terror that Bush took us into, a war on terror. Let me point out to you that that's no longer an enemy that has any substance. There's no borders, there's no country, there's no nothing. And you can't win it, ever. Never have in the history of mankind defeated terrorism. So when the transition from a conflict against a nation state to a conflict against a thing, you set up immediately a line of thinking that is perpetual. I just thought I'd point that out. Thanks.
Thanks so much, and thanks for being here and for your interest. Again, the question on the table is the 2001 AUMF still a constitutionally sound tool? And my answer is yes. I put this answer in the context of, yes, we passed it over 20 years ago, but I think we're going to talk a lot today about whether Congress has ceded its constitutional duties or not. But I think that the fact that it's been in place for over 20 years and that Congress has debated its use many, many times, Congress has had the opportunity to change the statute many times over the years, and will continue to have those debates. But I think that the absence of Congress speaking is sometimes, just as loud, if not louder, than the words on the page of a statute. And that's where I tend to, when we're talking about whether or not Congress should should take back its power. I think that the fact that we are debating these issues robustly and consistently, and have actually, as a body, have chosen not to repeal or pass a new authorization is quite telling. So I would say yes, it is constitutionally sound.
I could speak briefly on this one, and then sort of more, I'll expand on the next question. But I think sort of picking up maybe where Katie left off, in my experience, having worked in Congress for quite some time, Congress acts when there's a sense that there's imperative for them to act, when the constituents need them to act. When the executive branch is telling Congress, we don't actually need you to take a tough vote on this issue. We've got it. We will interpret the law in a way that doesn't put you on the spot. That's not the same as Congress giving its express support for something. So I think Paul's right to raise the steel seizure case. Justice Jackson's concurrence in that case is sort of the fundamental aspect that we look at in this. Just really briefly, it says, when the president's acting with the express will of Congress, his powers are at their greatest ebb. Who's acting against the express will of Congress, they're at their lowest ebb. But that doesn't just happen in a vacuum. I don't think you can say that just because Congress hasn't acted, that the president is acting against either the express or the implied will of Congress. It's express or implied will of Congress is the key. And I think what we're really seeing is an unfortunate situation where neither side has done the hard work of stepping up to fully live out what the Constitution envisioned in the balance of power. What the executive branch is doing is not trusting that Congress will provide them the authority that they believe the president needs, and not then putting Congress on the spot to take that tough decision, and instead giving them an out. And what Congress is doing is the same thing on their side. And that, I think, has left us in a situation where American men and women are fighting around the world under an authorization that was passed when many members of Congress today weren't even in office. And I think that is a pretty significant departure from the balance of power for this 20-year war that we did envision. And I think that's what's lost in this, is that that ability to ensure that we are continuing to have that balance of power. So I can expand more on that in the next question.
Great, yeah. So, we have this 2001 AUMF. It is, continuing to be used very regularly in the course of current modern day conflicts that probably weren't envisioned when it was passed. But it's also actually evolved a little bit over time, both in terms of where it's been used, the way it's been used, but how it's been interpreted. And in particular, it's now been sort of expanded to include associated forces. So as Professor Ahern said, the AUMF talks about, and I think Governor Gilmore said this as well, the AUMF talks specifically about those organizations or persons that perpetrated the 9/11 attacks. And now it's being used in cases related to associated forces. So I want to ask panelists, what is an associated force? What is the legal basis for expanding the AUMF to include associated forces? And what are the practical considerations and implications? And I think I'll start at the other end of the table now, start maybe with Mark and Katie, and then we'll come down if anybody has any questions. Okay.
Sure, I'll start. So associated forces, I think in a textual interpretive sense, I think you need to focus, again, we've kind of laid the context for how the 2001 AUMF came about, right? And I think it's important to focus on the threat, right? And the threat that President Bush was trying to, establish at the time is global terrorism, right? Acts of international terrorism. And so, I think that remains true today regarding the situations where we've used the 01 AUMF. And I think associated forces, if you take it in the context of the threat, are those forces that are planning or trying to plan or engaging in acts of international terrorism against the United States. So I think it's in terms of the threat, I think that's kind of where the analysis comes from.
I think when this concept of associated forces was invented by the executive branch without Congress, it was responding to a practical need, right? This need that there were forces that were joining alongside the forces that Congress had authorized the president to fight, and the president felt a need to fight them and was looking. It felt inconvenient, I think, to come back to Congress and look for continuing authorization to fight these ever-increasing enemies. The president could have done that, right? Like Congress was very clear to Paul's point. There's agreement that if the president is facing an attack or an imminent attack, the president can use force to defend America. We acted very quickly, as the governor said, after 9/11 to authorize the president to use force. Congress can act quickly when it needs to. When a force joins the fight against us, the president can act immediately and can then come to Congress for a new authority. That's there are pros and cons to that construct, but that is a construct that they never tried to do. What they did instead was say what Congress actually authorized in the 2001 AUMF. That's really important. The governor referenced it. It's not in the preamble. It's in the actual statutory text of what we're authorizing. And it's against, now I won't pull it up again, but against the people who attacked us on 9/11 and those who harbored them. It's not anyone who joins the fight against them, right? The president sought broader authority to do this global war on terror, and Congress explicitly rejected that in 2001. So again, the president's responding to this practical need, also a convenience of not coming to Congress, and then continuing to grow the authorization over time. And what we then end up with is not this forcing function in a democracy to ensure that America's elected representatives are part of taking America to war and keeping America at war, and instead something that's happening with a much smaller group of people, much farther from the public eye. And I think that having a democracy at war without having to have that public debate is missing something that the framers intended. I'll leave it there and go to the next.
I guess as an initial matter, I do want to quibble a little bit with the idea that we're at war with a thing rather than people. I mean, the AUMF is specific about organizations, entities, acts of international terrorism, and what we're at war with, broadly speaking. I mean, you can pull out a number of different sort of definitions of terrorism from the U.S. Code, but broadly speaking, it's people who use violence to intimidate or coerce a civilian population, or to affect the policy of the government through intimidation or coercion. That's what we're at war with, those people. Now, the concept of associated forces, obviously it's not in the original AUMF. The AUMF itself, the authorization by its text, is focused on those who committed or harbored people who committed the acts of 9/11. But there's at least 4 different avenues to get to associated forces, even without using a broad conception of Article 2 authority. One is through Congress's directive to use all necessary and appropriate force. If it is necessary to achieve the objectives of the AUMF by going after people who are associated with Al Qaeda rather than just core Al Qaeda, that's one way to get there. A second way to get there is through the Supreme Court. In a case called Hamdi, the Supreme Court had to review the detention, in that case, of a U.S. citizen. And what the court said was that the AUMF encompassed also things that are regularly incident to fighting an armed conflict. In that case, it was detention. We can read that opinion to mean that other incidents of prosecuting an armed conflict are also sort of authorized by the AUMF. This idea of targeting associated forces, I would argue, is a traditional incident of war. And you can pluck out many examples of this, but during World War II, one of the first U.S. Army actions was Operation Torch in North Africa. So they landed in North Africa, and facing them were the forces of the Vichy French. And we didn't declare war on France. They were associated with the Nazis that we had declared war on. So there's that. This is the third one is my least favorite, and you could argue this up until 2012, which is congressional acquiescence. All right, the executive branch was interpreting the AUMF this way very clearly, very publicly. To your point, there hadn't been any sort of congressional pushback on it, and so you could interpret it that way. And then finally, in 2012, Congress reaffirmed the executive branch's authority to detain people under the AUMF. And they spoke of the covered people that could be detained. And in that definition of covered people, it included associated forces. So any one of those bases, I think, gets you to the idea of associated forces in particular. But I do sort of refer back to the broader conception that what the AUMF directs is for the president to prosecute a war against terrorists so that something like 9/11 doesn't happen again, maybe regardless of who those people are associated with.
And I'm trying to work this out while we're in the middle of the symposium, as a matter of fact, but Paul is right. War on terror is against a thing, but that's an instrumentality that we use against the United States and all of our allies, and frankly, all of Western civilization. But he's right. There are people who are using that instrument. Then we have a right to go to war against those people. So he's right about that, absolutely. I think that I might just mention that we may be shifting back from these disorganized associated groups back to the nation state thing again. We're in a hybrid war. I think we're going to talk about maybe gray zones after a little while. I tried to figure out all what that meant, and I never quite got there, but I think it's the concept of hybrid war, which is the use of terror as one instrument against an adversary. I point out that the Russians today in Ukraine, it's a nation-state conflict, but the Russians do not accept Ukraine as a country, and they are using the instrumentality of terror in order to try to cow the Ukrainian people and the Ukrainian state. As recently as this very morning, as a matter of fact, civilians were attacked by drones in Ukraine, and they're not going to win the war by killing 8 more civilians this morning. They're doing it in order to terrorize the people of Ukraine, and by extension, their allies, including the United States.
Could I add on that just a brief point before we move on to the other ones? Because I think one of the sort of conclusions I've drawn over the years is the way the executive branch reasoning happens is largely in the way sort of Paul laid out, that there is a problem and lawyers go back to the law and they find ways to justify within the law solving that problem. The only place this is really litigated is in these habeas cases. That the vast majority of other questions about whether or not the president has authority at war are ruled out as political questions. So courts aren't going to hear them. And the overall point, I think, on associated forces is that, in my view, there's a line somewhere. There's a line somewhere between sort of the core groups who join the fight and other, for very attenuated groups on other sides of the world that maybe don't even have the capacity to attack the United States. But because this argument was now available, it got stretched. And when associated forces was first conceived of, it was controversial. But then once it sort of gets indoctrinated into the canon, you can stretch it a little bit more, and you can stretch it a little bit more. And at some point, you've broken the rubber band, but all you have are lawyers of the opposing parties arguing with each other with no neutral arbitrator to decide who's right or wrong. So the bottom line is, the executive branch goes to court on cases all the time. And the litigators believe overwhelmingly that they're right, that what the president can do what the president's arguing to do in court. But we all know many cases where courts overturn what the executive branch wants to do. And in these questions, that never happens. There's Congress, in some cases, pushing back. But even in the cases where Congress has passed a resolution to require withdrawal of forces, the president vetoes it. So then you need a veto-proof majority in Congress to keep the president from asserting his view of the law. And that's, I think, just a really important context, that as we're building this president over time and then citing the president as law to build on it more, has never been litigated by a neutral arbitrator. And the check is only, can Congress stop it with a veto-proof majority? And that's a huge bar.
Let me ask a question. So I'm going to ask the group a question. What's not an associated force? What's not within the realm of presidential or power to attack? Is associated force anybody anywhere who acts contrary to the national safety of the United States? Whether it's organized or a nation state or whoever it is, who will it be tomorrow? An associated force could be anybody that's wanting to attack the United States. It doesn't have to be militarily, by the way. I'll talk in a minute about this business of hybrid warfare. It goes far beyond military attacks on the United States.
At the risk of prolonging this, I would say when the military captures somebody that could be prosecuted, but they choose to let them go, maybe in the middle of the desert in a country in the Middle East, or maybe back on the shores of a country in the Western Hemisphere, it's probably because they don't feel really confident about their argument in court.
So it's a good segue though, because we'll get to hybrid warfare in just a second. But before we do, we've got this AUMF now, and we're arguing and thinking about and interpreting like what it can be used for how long, is it still valid? But as Paul pointed out, in Youngstown, the president can also act without Congress, and Article 2 tells us that. Now it's pretty broad, and so understanding what Article 2 actually means, we look to case law and we look to all sorts of different things. And in the executive branch, they look at the DOJ, Office of Legal Counsel opinions, and again, may or may not agree with how those have been interpreted, but what OLC has said in the past is that the president can take action in national self-defense if it's in the national interest and if it doesn't constitute war in the constitutional sense. That's not a clear bar, but that's a bar that you work with, right? So is it in the national interest and does it equal war in the constitutional sense? And different administrations have interpreted that in different ways, but pretty broadly in terms of when the president can use military force. So I guess I want to talk a little bit about Article 2 and ask, what are the limits? What are the modern limits to Article 2 authority for the president? If we either don't have an AUMF or think the AUMF has expired or is not relevant to this particular conflict, where does Article 2 power stop? What can't the president do? What is imminent? What is an armed conflict? So I think I will pause there. Either I can let Governor Gilmore, if you want to take the first crack at that, or I could ask Paul to take a crack at that. Want to start? Okay.
I'll be brief because I'm trying to work some of this out. Okay. It's perfectly clear to me that the founders didn't contemplate this total, permanent, universal power to the president to make war. They intended specifically for the Congress to have the power to make war. It's the events of the ages that have changed that around as time has gone on. I think that's all I'm going to say right now. I'm going to listen to Paul and see what I can learn.
That's highly dangerous. There's a corollary to Godwin's law. Does everybody know what Godwin's law is? It's this principle that if an internet discussion goes on long enough, somebody will be compared to Hitler or Nazis or something like that. There's a national security law corollary to that, which is that if a national security law discussion goes on long enough, it'll eventually talk about torture. And so that's sort of the thing that Governor Gilmore was talking about with the John Yoo memos. And I bring this up, first of all, to just go ahead and get that corollary out of the way, and let's do that. But more for the principle that when OLC revisited the 2002 memo, the John Yoo memo, eventually came to the same decision, but got there differently and sort of repudiated the part of the Yoo memo that focused on plumbing the depths of Article 2. And how much does Article 2 allow and that kind of thing. It was unnecessary to reach the answer to the questions that were posed there. And I think similarly, I think it's difficult to plumb the depths of what Article 2 allows. And I think it's somewhat dangerous because we need to maintain flexibility, I think, to deal with threats that we don't know about right now that may be beyond our conception. So I'm not going to sort of opine as to what the limits of Article 2 may be. What I will say is that in the armed conflict that is the subject of the AUMF, I think the first thing we look at is the AUMF and some of those whereas clauses that I'm talking about. If we're talking about an activity that the president wants to do that doesn't go toward deterring and preventing acts of international terrorism, then maybe arguably it's outside of the scope of the AUMF. Now, maybe the president's authority independently allows him to do that. It would depend on what we're talking about, but that's kind of what I would look at in terms of this particular conflict.
Yeah, and as a creature of the executive branch myself, I very much appreciate and recognize the desire to remain flexible on Article 2. So I'm going to look to our legislative colleagues who might have a different view, but I don't know. Katie, do you want to start?
Sure. The answer that I have to this one is we don't know, right? We are attorneys. We are presented with a set of facts, and we analyze those facts, and we give our clients, in our case, principals, constitutional actors, we give them legal advice. But the fact of the matter is, we laws exist, and we argue the limits of them all the time. And so, if in terms of what the limits are, I think because of the changing threat environment that we are facing, and because of the advancement of technology and the use of technology in war, and we're going to talk about that a little more, but the fact of the matter is that in the future, when a situation occurs, we are going to be presented with those facts, and we are going to apply our analytical framework to that set of facts. And we'll have to give that advice. That's what executive branch attorneys do. That's what legislative branch attorneys do. But I will say, in applying that, there is an analytical framework, but I would say that none of this actually does happen in a vacuum. And I would just say that, Mark, you mentioned the absence of a neutral arbiter in some of this, and I would just argue that when the court dismisses something as a political question, the basis of that jurisprudential doctrine is that something is a political question because the courts shouldn't decide. But who decides if the courts don't decide? The American people. So I would argue that the American people get to elect our representatives, and if we don't agree with with the framework that our representatives or our president have laid out, then we have the opportunity to exercise their democratic rights and vote them out of office. So I would say that these issues do get litigated one way or another.
In the spirit of bipartisanship, I'll agree with taking the last point, right? But that is how these are supposed to be decided. I think the steel seizure case is relevant in this instance because the president is acting against the express will of Congress. There's a lot of implied will of Congress in appropriations law and other things, but what the War Powers Resolution says specifically is, unless Congress is authorized, the president can use force in a national emergency created by an attack on the United States, its territories, possessions, or armed forces. Now, I don't think there are many people who think that's the entire scope of Article 2, but that is what Congress said. So that's the express will of Congress. And then anything the president is doing beyond that he's doing because Congress is not empowered to stop him from doing it. So I think that that's a very different way than the OLC looks at this. And I think that's an often sort of overlooked the preamble to the War Powers Resolution, but since we're relying a lot on preambles today, why not bring that into it? So that's the first thing. The second thing is the details of the OLC's view is how do you define war in the constitutional sense? So you look at the nature, scope, and duration of the conflict. And I think it's remarkable that we're very hard pressed to find an example of a time when executive branch lawyers didn't look at the nature, scope, and duration of a conflict, even conflicts that everybody in the room would see as wars, and find that it met the standard of war in the constitutional sense. And I think that is where I end up getting concerned there's not a viable check.
All right, thanks. So let's then think about the evolving nature of war. Somebody started talking about that down there. And the fact that war has evolved quite a bit over the last century and looks very different today even than it did 20 years ago. We've got autonomous weapons and drones. We've got cyber warfare. We've got gray zone conflict. We've got space conflict. We've got non-military types of conflict, as Governor talked about. How does that world now and this current world and the continued evolution of what a weapon may be and where it might be used impact the separation of powers and the balance of powers? Gilmore, you want to start?
I guess I'll start by talking briefly about the way that I see the world right now. We've emerged from a period in which we all say, well, we can't have a war because there's these nuclear weapons out there, and we'll destroy everybody and everything if we have a conflict. What's emerged today is the concept of hybrid war. It's a war that's underneath the umbrella of the nuclear threat. And you see it going on all the time, but I would urge you to think about war as different from just military conflict on the battlefield. Hybrid warfare means that you take all the elements of a country's national power and direct it at an adversary. And I hasten to say, how do you define adversary? And I think it's pretty significant to look at what the national objective of a country is. And then you know whether or not it's in the best interest of the United States or not. So very quickly, I think we know what Putin is trying to do. He has told us what he's trying to do. And so I think the fundamental political question is, should we just let him do it? Should we just let him destroy Ukraine? Should we just let him reassert himself in the Baltics and the Eastern Europe? Should we allow him to poison the politics of Western Europe? If Europe is neutralized, is that in the best interest of the United States? I feel arguably, assertively, it is not in the interest of the United States, which is why we have, I think, a stake in the conflict. But think about war differently from just the battlefield. As Clausewitz said, war is just an extension of politics. We're only talking here about geopolitics. We're really not talking about war. We're talking about geopolitics. What is it that a country adversarial to us is trying to do? And then at that point, look and see at all the elements that can be brought to bear. And what are they? Just very quickly. Well, there's military, of course. There's economics. Are we watching sanctions now being scattered all over the place to try to force an adversary to our will? Cyber. Everything now is connected to cyber that, and frankly, can become a communications message that's challenging. And finally, I'll stop by saying, as a lifelong politician, the most powerful element of a country's national power is the sense of its righteousness, its values, and the ability to communicate a message to those values. Because at that point, you win the argument about whether or not you should be engaged in a conflict at all. It lays the foundation for a military intervention or military activity, which is just one little element. But the main point is, oh, by the way, hybrid war also includes this thing we've been talking about in the gray area. The Russians right now are engaged in sabotage, assassination, blowing things up, incursions into other airspace, all kinds of things right now that are going on that are pretty aggressive. And it's all part of something less than a complete and total declaration of war and conflict in the World War II sense. But that's the nature right now of modern conflict, and we have to understand it and come to grips with it.
Anybody else want to talk about this one?
So we often talk past the executive branch and those in Congress that are advocating for stronger enforcement of the War Powers Resolution often end up talking past each other because of the terms that are used on either side and a lack of coherence between those terms and definitions. So the question of sort of how is the evolving nature of conflict affect the authorities to initiate the use of military force, those terms and definitions are really important. Then what the War Powers Resolution relies on is the term hostilities. And although there was consideration in Congress of defining the term, they didn't define it. So that then left to the executive branch an opportunity to define hostilities. It's been defined exceedingly narrowly, in my view, and in a way that as we develop more standoff weapons and autonomous systems, narrows Congress's sphere of control over the use of military force in really significant ways. What the executive branch has decided to do unilaterally is conveniently define hostilities as active exchanges of fire between opposing units of hostile forces. So unless we're shooting at them and they're shooting at us, it's not hostilities. And then what the War Powers Resolution requires is if U.S. forces are introduced into hostilities or situations where imminent involvement in hostilities is clearly indicated by the circumstances. So there has to be hostilities there. Then the War Powers Resolution kicks in. That opens an argument then by the executive branch to say, if they can't shoot back at U.S. forces, Congress is not implicated here. And then a real reliance on this idea that the only purpose of the War Powers Resolution is to prevent US troops from being in harm's way directly. And that's not the way the War Powers Resolution has been used historically by either the executive branch or Congress. That the executive branch, they always say they're acting consistent with the War Powers Resolution, but they send notifications for strikes that are conducted with standoff weapons. And there was a time when the executive branch appeared during the start of the conflict in Syria, where they appeared to think that even though U.S. forces might have not been introduced on the ground, might not be in harm's way, these airstrikes would trigger the 60-day clock in the War Powers Resolution and require the president to stop using force. And we know that because they would send notifications more frequently than 60 days and say, the last conflict ended and we just started a new one against the same enemy using the same means, but it's new and the clock reset. And they've now jettisoned that effort. It appears entirely. And so it's already not working well now, and it's been stretched even farther. And if we end up in a place, just to conclude, where we have cyber conflicts or autonomous conflicts, and we do care about Congress's role in more than just whether there are U.S. forces on the ground or U.S. forces taking fire, we're going to need to update definitions in a way that accounts for that.
And I'll just quickly state, I agree with a lot of what Mark just said, but the War Powers Resolution is, of course, a check on executive power. But I think, again, I will just highlight that I think part of the way that the War Powers Resolution has been used most since it was passed is as a mechanism for forcing debate. And that's public debate on the floor, right? So what you don't really think about a lot in law school until you get into these jobs is the fact that the War Powers Resolution includes, very, very importantly, expedited procedures. And that means if you file a resolution under the right conditions, then you get expedited debate on the Senate floor. And I think it is the most precious resource in the Senate is time on the floor. And yet the War Powers Resolution allows for this mechanism for us to have a temporal debate on these situations in real time. So I would say that that's another check on executive action is Congress's ability to debate in real time and have that transparency to the American people.
Yeah, thanks. I think those War Powers Resolution points are really, really important. So thank you guys for talking through those. So we are at the time when we were supposed to start questions. And so I'm going to do that in a second. But before we do, I just want to speed round really quickly and just go down the line. We didn't talk about international law yet. Maybe in the questions it'll come up. But do the Constitution, the AUMFs, the domestic law, and the international law form a coherent, legitimate legal architecture? Or is it like a fragmented ad hoc system where executive power is filling the void and ambiguity? And I think like a quick 1 or 2 sentences, and then we'll open it up to questions. Do you think it's a coherent legal architecture, or are we allowing the executive branch to just fill a void?
I don't think we have a coherent structure at this point. I think it's grown up like a weed and is buffeted around by issues. So I think that, frankly, this is a good time for the Congress probably doesn't want to take this on because we're in a global conflict right now. The Congress doesn't want to take the responsibility of stopping the executive from being able to respond. And even on war and terror, you got to be in the fight. There's no doubt about that. So that's why that power has flowed to the president. I don't think we have a coherent structure, though, at least not yet, not in my opinion.
Yeah, certainly I agree that there's no coherent structure. I don't think that's unique to this area, actually. I mean, if you're kind of, as we all are, a student of American law, I mean, that's kind of the way things work in a common law system. It grows up like a weed. That has a lot of benefits. It has a lot of benefits in terms of flexibility and all those other things that I was talking about. So that's point one. Point two is that I wouldn't look at Article 2 necessarily as filling the void. Article 2 it reflects a choice by the founders to allocate responsibilities in the government. And so, on these issues where, the president has certain institutional advantages, the ability to act quickly, primacy over foreign affairs, you can get down into the weeds, even to access to information that maybe Congress doesn't always have immediately. The president was designed as the actor who did these kinds of things. So it's not so much a filling the gap. It is just the president is occupying his place in the constitutional structure.
I would argue that it is coherent in the sense that we have an analytical structure that can be applied in unforeseen circumstances, right? So the president has the flexibility to act. That ability to act may be checked by Congress when Congress sees fit. And in the meantime, Congress can debate it, right? A lot. And the American people can accept or reject that through our political system. And then when we pass an actual authorization for the use of force, those penumbras that you love or hate maybe to think about in a law school exam, those penumbras can align, and it can be coherent in that sense. But again, I would say that it is coherent in that it is varied and provides different levels of depth for debate and analysis for unforeseen situations.
I think these are all really important points, but the bottom line for me is I think we often end up talking past each other. I think the executive branch is talking about one thing, they're talking about whether this is war in the constitutional sense, or analyzing their own president and opinions, and Congress is talking about the War Powers Resolution and the terms in that, not Congress as a whole, but that's what we end up debating, to Katie's good point about how the War Powers Resolution forces debate, and we end up then having separate debates and talking about separate terms, and I think it doesn't do justice to the project when we end up talking past each other.
Great, thanks. Okay, so that means that all of you are going to have a lot of good jobs as you come out of law school, because we have a lot of work to do still. Who has got questions? Let's open it up for questions. Sure.
Yeah, so sort of coming back to the.
I'm going to give you this mic. Hold on.
All right.
Like Oprah.
So coming back to the, AUMF is against a tactic, or against people who use a tactic. The tactic expands to include things like cyber terrorism, narco terrorism, etc. And associated forces can expand to include state actors. Are we actually just at the point where the AUMF has sort of eaten the war powers of Congress, where the executive can use force against effectively anyone in the world at any time, subject only to the one-way ratchet of a veto-proof majority? And is that actually what we need in today's threatening world?
So I'll open it to any of you.
And I think my views are probably clear, but I just want to clarify that for all the textualists, and it's remarkable when conservatives stop becoming textualists. The AUMF is not against the tactic; it's against the entities that attacked us on 9/11 and those who harbored them. It's not against terrorism as a tactic. We could have authorized that, but we didn't. And I do think that this effort I don't think it's wide open, but I think we haven't talked about the 2002 AUMF at all. The 2002 AUMF was against threats emanating from Iraq, or the threat of Iraq. I didn't pull it up and have it in front of me, but one or the other is definitely not Iran. But we used that to attack, to kill Qasem Soleimani and Iranian general, because he was in Iraq, and then we used that and the 2001 AUMF to go to war in Syria against ISIS that didn't exist on 9/11 and was actually fighting Al-Qaeda that did exist in 9/11. So what I do think is that there are limits, even in the executive branch's view, but they ended up being stretched to cover this entire tactic of terrorism, or at least Islamist terrorism, including even groups that were fighting each other.
I think the 2002 AUMF focuses on emanating out of Iraq.
That's what I think.
That's a whole nother analytical structure, right? But I think we can talk a lot about Congress and what's wrong with Congress, but again, I will just say that administrations on both sides, right, have cited both the 01 and the 02 AUMF, even in situations where they argue that they had clear Article 2 authority. I certainly agree that this is a debate that should continue, and it is ongoing and should continue. But I think in terms of, is it something that's gotten old? I mean, I think that I think you've seen administrations on both sides cite it. So.
Yeah, I guess one thing is that I think the AUMF itself contemplates action against nation actors, right? So that's in the AUMF. So I don't know that that's necessarily an expansion one way or the other. I think when you're talking about cyber and other sort of mechanisms of terrorism, those are just the mechanisms. Those are the bombs. Those are the whatever you're targeting as a terrorist. That core aspect of international terrorism is still. I go back to that. And so when we're talking about the AUMF, I think it can broadly cover, any means or instrumentality of, acting with violence to coerce civilian population and everything else. That doesn't speak to the sort of the rest of Article 2, right? And I think, we're talking a lot about how the AUMF is being used to stretch and cover things that it wasn't anticipated to cover. I would just posit that that's maybe a better world to be in than if the president is relying solely on Article 2. All right. So at least Congress can amend the AUMF. All right. And if it disagrees with sufficient margins with the president's interpretation of the AUMF, it can change it. That's much harder to do when the president says, look, I'm operating under my Article 2 authority. So I would just suggest that rather than sort of castigate the executive branch for stretching the AUMF, maybe we should think about that instead.
Maybe happy birthday.
Yeah, let's all celebrate the AUMF.
I find myself wondering whether the War Powers Resolution is still valid or not, or whether the AUMF has superseded that at this point, and it is the governing principle, which we have said here is stretched unlimited to almost anything that the president thinks he needs to do in order to protect the country. So I'm wondering about that. Just as one little add-on here, let me urge you all to think beyond just military here in the modern world. I would remind you all that a country can be defeated without military force. I would argue that Israel is losing the war in Gaza because of the political reaction to what they're doing. Political reaction. The United States lost the Vietnam War because of the domestic things that were going on here that put too much pressure. And the Soviet Union fell without any military conflict at all because of its clash of values, which we won. So you can defeat an enemy without military force in the modern world. That's called hybrid warfare. And the United States can be defeated too. The United States can fall without anybody attacking us militarily, even a terrorist, in the contemporary modern world.
Yeah, and I think one more thing to think about in the context of this question is whether in the future, if Congress wants to sort of reclaim some of its power, should it be thinking about sunsets on AUMFs or a regular reauthorization of the AUMF or things like that? They've got to think a little bit further in advance about how to use their power. We have a lot of questions. We have 2 minutes. So I will take a few and then you guys can feel free to just come up and ask your questions afterwards. At least hopefully a few people can hang around. So the guy all the way in the back row in the yellow, tan jacket, I saw his hand first.
Hi, my name is Chase Masters. I'm a 2022 graduate of the International Security Program across the hall. I thought of a quote from John F. Kennedy brought by what Governor Gilmore said, and that is, let us remember that foreign policy can kill us and domestic policy can only defeat us. At what point do our domestic policy decisions become so costly in our conduct of foreign policy that we have to sort of put them on the back burner?
I'm not sure I completely understand the.
I'll rephrase. Are there domestic policy decisions that can make us uncompetitive in conduct of foreign policy? Be they energy restrictions, be they change policy or on themselves. And they'll take
You get it?
I think so. Yeah.
You start now.
Yeah. Okay. So I'm not sitting here as a policy guy. I'm not really a policy guy. These are sort of policy questions. I think theoretically you can posit some circumstances. If we rare earth metals, let's say there's an example for you. If we find ourselves in a circumstance where we cannot supply ourselves by one means or another with the rare earths that we need to keep our defense technology competitive, if not, better yet, even above peer. That could be a policy choice that sort of affects us.
Well, let me take one quick stab at it, and that might be that the all democracies are inherently weaker than authoritarian countries because we have to create consensus. We have the First Amendment. We have all these opportunities for protest, which is going on in law, speak, all those sorts of things that weaken us. Versus Putin, who doesn't have to worry about any of that stuff. And so the challenge for democracy going forward is how do we harmonize our values and our freedoms in this international conflict that we're in.
Thanks. Okay, I'm gonna give Garrett the last word because he's part of the host.
That's Garrett too.
So I just had a quick question because I think it's something that is on a lot of people's mind. So recently in the Caribbean, President Trump has been issuing airstrikes upon ships that are allegedly carrying drugs to the United States from two major cartels, Tren de Aragua and the Cartel de Sol. So does the president have the authority to conduct these airstrikes? And if so, where does he have that authority?
Okay, we're gonna make this a speed round. Who wants to start?
Start at that end.
Do you want the first word or the last word?
I'll give you the last words. The majority always gets to it. I think the question. I'm not going to give sort of a definitive view, but I'll talk about what people on either side are saying. Or I'll talk about one side, and Katie can talk about another side, I think. So the members of Congress who have been pushing it back against this, sort of the fundamental question that's distinct from other issues of the use of Article 2 force is the question of whether or not we were in an armed conflict. And once you decide that we're in an armed conflict, then you can follow down the line of reasoning about expansive Article 2 authority and analogize to other strikes that we've all become accustomed to the president conducting strikes. I think the place to pause is at the very beginning. In order to have an armed conflict, you need to be attacked. I haven't seen anything that's happening that meets the definition of an attack that has ever been accepted before this, or the definition that I'm aware of in international law. So then you're in not an instance when the president is using force in an armed conflict, but a situation in which the president has ordered the military to execute suspected criminals outside of an armed conflict. And there's a whole nother legal regime for whether or not the president can order the military to execute suspected criminals. And I think the place to focus on is that initial question of which regime we're in.
Does the president have the authority? My answer is yes. I think if you apply the analysis pretty clearly, the answer is yes. The threat is the focus here, right? These are narco-terrorist groups. The president has designated them as narco-terrorist groups. That in and of itself is not the justification for the use of force, right? But it is a factor in the analysis for whether or not to use military force. And I think that I think Professor Ahern outlined other examples earlier, but I think a lot of debate in this area is focusing on the fact that we're just bombing ships out of nowhere, but that's not the case, right? We've tried to use other authorities for decades, and I think what you're seeing is the president acknowledging the fact that Title 14 authorities and other law enforcement authorities have not worked yet, and because of that, and because of because of who these groups are, they're violent narco-terrorist groups. And not to mention that, but these drugs pose a threat. Drugs are killing thousands and thousands of Americans every year, and these groups are employing violent tactics. Across multiple countries, right? But violent tactics, and they're putting drugs on boats that are intended that could pose a threat to the United States and Americans. And the president has acknowledged that fact and has said that, because of that acknowledgement, that's a justification. And I think it's valid. And I think, if you know anyone that's lost their life or has struggled with some of the drugs that are coming from these narco-terrorist groups, I think, a lot of the American people agree.
I'm not sure if this is working or not. You remember what sort of the history that led up to 9/11, right? And we were in an armed conflict long before we even recognized it. 2 decades before that. Through the 80s, we were also engaged in this war on drugs, right? And people say that's a rhetorical thing, this war on drugs, everything like that. But I could see an argument for maybe we have been in an armed conflict with these narco cartels all along, and we're only now just recognizing it, kind of like the 9/11 scenario. So I have no idea what the actual justification is here or what the administration has put forward, but I could certainly see the argument that we have been in our conflict and are now addressing it that way.
Yep. So I'll ask, it's on now? Okay. So look how far we've come. The 9/11 resolution was responsive to a direct military type attack on the United States that cost those thousands of American lives. The Congress and the president reacted to that. I'll just ask you a question. If the cartels are delivering drugs into the United States, is that an attack on the United States within the thinking of the AUMF? Is it? And I have the next question would be, can I imagine other ways to attack the United States non-militarily? I can imagine a lot of ways that the United States could be attacked non-militarily. But it's perfectly clear the thinking right now is Americans are using these drugs. These people are delivering them. It has a quasi-political impact to it. Therefore, we can kill them. And that's different. And it's worth, I think, discussing.
Just one final point on that. I mean, I don't think China is sorry that they're sending, fentanyl precursors into the United States. I mean, what that does to our society is to their benefit. I don't think Venezuela is sorry that they're sending cocaine to the United States. I mean, there's an aspect of this, if you think about it, where it looks like an armed attack. I mean, it is directed at undermining the United States. At least that's the theory. And so, again, I go back to my general theme that I think our system needs to maintain enough flexibility, at least, to be able to deal with things like this that are killing hundreds of thousands of Americans in whatever means we can.
I said I'd give Katie the last word, so maybe hopefully she has something else to say. But I'll just say, as lawyers, what we're supposed to do is look at definitions, right? And so what I encourage everyone to do is look for the definition of an armed attack and then reach your own conclusion. What we've heard is a lot of sort of policy imperatives, right? But as lawyers, we don't look at policy imperatives, right? That's part of a larger discussion. But our job is to say, do the facts meet the letter of the law?
I will just end with, we can talk about armed attack, but Article 2 is based on the president's ability to take action to defend the United States, our interests, and the American people, right? Americans. And I think that's what the president is trying to do here, right? And we have precedent, a lot of precedent under Article 2 for much, much broader operations. I would cite President Obama in Libya, right? I think it was over 500 attacks that President Obama ordered in Libya. And that's a lot farther away than the Caribbean, which is our backyard. It's our southern border. So, I think there's a lot one could argue that this is well within, and this is, I think this is, Congress has already had 2 debates on this topic. We've debated for 2 days. The government was shut down for 43 days. We spent 2 of them debating this current use of force. That's really significant. It might not sound like a lot to you. Again, it is the most precious resource that Congress has, is time. So we've already had 2 votes on this, and Congress has clearly said that the president is acting well within his constitutional authority, and in fact, maybe his duty, right, to protect Americans in our own backyard.
So this topic in question is worthy of its own hour panel or more, probably. It's an incredibly complicated issue, and we can't do it justice here in 5 minutes. So I would just encourage you to read everything you can about it, come ask questions, talk to people you know. I think it's, as you know, in law school, reasonable minds can differ, and the facts matter, and the law and how you're analyzing it and applying it matters. And there are a lot of lawyers looking at these things on all sides, coming to different conclusions. So I think that is just evidence that it's a really novel application of the law, and we have more work to do to figure this out. But I'm conscious of the time, and I know that you all in your studies will probably help us think through this. So I appreciate that. Thank you for coming. Thank you to the panel, all of you for coming and for spending the time with us to talk about these issues. If any of you can stay after, I'm happy to stay and take questions as well. But thank you guys for coming and staying for an extra 10 minutes and participating. Really appreciate it. It was good to chat with all of you. Thank you.
Great fun.